Good morning, and thank you for joining us for our webinar this morning about how to survive and conquer a DOL health plan audit. My name is Michelle Montoya, and I run the compliance department for Felice Insurance. And I'm joined here today by our attorney, Deborah Hyde. She's a new ERISA attorney that's been added to our staff, and so she's going to help us get through what it is that we should expect from an audit. What is ERISA? How does it relate, and how is it managed by the DOL? We're going to talk about what the process is like, what you can expect, and we're also going to talk about how to minimize your exposure. Why are we doing this webinar? The Department of Labor has hired a number of new auditors. So we have seen a number of benefit plan audits happen. The uptick is high. We have had 2 of our clients so far this year get audited with successful results, and so we thought it would be a good idea if we were to share our experience with you. Some logistics about this webinar this morning. The system allows you to type in questions. Some of them, there's members of the compliance team that can answer the questions as we go along. Any that are out there that we haven't answered, we will answer towards the end of the webinar. At the bottom, you'll see some widgets. The Q&A is the one that you would use to ask some questions. There's also a help section. If you're not hearing my voice right now or something like that, click on help, and somebody from our team will jump on and help you with that. There is also a slides widget where you can download the slides, and there's also a link to Felice.com where we have a document that supports the webinar this morning where you can get some more information. So with all of that, we're going to go ahead and get started. We don't think that this will go the full hour, but we'll just see how many questions we have and how we get through the material. All right.
Okay, thank you, Michelle, and good morning. So throughout this morning's webinar, we will be providing you with a lot of really useful information about what you can expect from a DOL group health plan audit. But before we dive right into the details of the audit process, I do want to take a few minutes to briefly examine the regulatory framework for group health plans and really gain a better understanding of what guides the DOL throughout an investigation. So the Department of Labor has the authority to regulate and investigate ERISA plans. What then is ERISA, and what exactly is an ERISA plan? The Employee Retirement Income Security Act is federal law that sets minimum standards for employer-sponsored group health plans. It does not require employers to put in place a group health plan, but it does set strict guidelines for those plans once they are implemented. ERISA applies to fully insured, self-insured, and partially funded plans of all sizes. There is no plan too large or too small to fall under the purview of ERISA, and some sponsors mistakenly believe that because their plan is so small, maybe they only have a few participants, a handful, that they are not subject to ERISA regulation, but that is simply not the case. There are, however, 2 categories of plans that are exempt from ERISA regulation, and those are state and local government-sponsored plans and church plans. So unless your plan falls under one of those 2 categories, it is very likely an ERISA plan. So ERISA prescribes 4 essential elements necessary for each group health plan. And these elements are a written plan document by which the plan will be operated and administered, a fund to hold plan assets, or in the case of an insured plan, a carrier to retain premium payments. ERISA requires a record-keeping system. There are some guidelines concerning record retention, so a record-keeping system is a must. And finally, ERISA requires communication and disclosure materials for employees, participants, and beneficiaries. ERISA regulation is not limited to just the plan itself, however. It also sets out strict guidelines and standards for the individuals responsible for the plan. And these individuals are designated under ERISA as plan fiduciaries. Well, who are the plan fiduciaries? Fiduciaries are those who exercise discretion in the management or administration of the plan. This is a functional definition which means that the title of the individual has no bearing on his or her status as a fiduciary. It's all about the role that that individual plays in relation to the plan. It's also important to note that fiduciary status is not something that is in place 24/7. It is only when that person is exercising discretion in the management or administration of the plan. So some examples are employer sponsors. Employer sponsors are often fiduciaries, whereas plan administrators, trustees, and claims administrators are always fiduciaries when acting in this capacity. The DOL also makes a distinction between fiduciary decisions and settlor functions. And settlor functions are really those business decisions that are made about the plan. These are decisions about whether to put a plan in place and the contribution levels that you're going to implement, or even the decision to terminate a plan. These are all business decisions, so you are not acting in your fiduciary capacity when making these decisions. You are acting in your business capacity. Plan fiduciaries are charged with several duties under the law, and these fiduciaries are widely recognized by courts as the highest obligation known to the law. And the 5 core fiduciary duties are the duty to act in the sole interest of participants and beneficiaries with the exclusive purpose of providing benefits. This is also referred to as the exclusive purpose rule. Fiduciaries have the duty to act prudently when making decisions about the plan. The duty to follow plan documents. And the only exception here to this rule and this duty to follow plan documents is where a provision in the documents conflicts with ERISA. And of course, in that case, you have the duty to follow ERISA rather than the plan document. You have the duty to hold plan assets in trust, or in the case of an insured plan, you need to remit premium payments directly to the carrier in a timely fashion. And you have the duty to pay only reasonable plan expenses. You may be noticing that these duties are somewhat subjective and a little bit vague. What exactly does it mean to act prudently, or what qualifies as a reasonable plan expense? And over the years, the federal courts and the Department of Labor have had ample opportunity to expound upon these duties. So there is plenty of guidance out there to assist you in evaluating what exactly is required of you. But we won't be going into that level of detail today. Of course, with fiduciary duty comes the potential for liability. And fiduciaries may be held personally liable to restore any losses to the plan. Personal liability may come as somewhat of a surprise to some of you, but the good news here is that liability can be greatly limited in a number of different ways. So one way that you can limit your liability is by demonstrating proper and prudent conduct through a thorough documentation process. It's really important to implement a documentation process that is consistent and accurate. You want to be documenting decisions that are made concerning the plan, or any issues that might arise concerning plan operation, or a complaint from a participant. You want to be sure that you're also, of course, retaining these documents so that you can rely on them if ever your conduct is called into question. You can also limit your liability further by hiring service providers and delegating some fiduciary duties to others more experienced and knowledgeable. So the DOL is aware that plan fiduciaries are not experts in all areas of plan administration. And so they're aware of this, and they actually encourage fiduciaries to hire service providers to assist them in their responsibilities to the plan. So a really common example of this is the claims administration process. This duty is often delegated to a third-party administrator, or in the case of an insured plan, to the insurance provider. And then also co-fiduciary liability. So yes, fiduciaries can be held liable for the misconduct of their co-fiduciaries. And this occurs where a fiduciary is aware of some misconduct by their co-fiduciary and does not take any action to remedy that misconduct. So a really great way to limit your liability here is through the consistent monitoring and oversight of your co-fiduciaries. Just don't be in the dark about what your co-fiduciaries are doing. Stay in contact, stay in touch, and just be aware of the overall plan operations. If you have reason to believe that if there's any misconduct occurring, you do have a duty to investigate and to take action necessary to remedy that. So to really simplify here and generalize a little bit, you can fulfill your fiduciary duties in the operation of the plan in several key ways. So through the proper handling of employee contributions. What we're looking at here is really the segregation of plan assets from the general assets of the business. If you are a self-funded plan, you need to have a trust or a separate account set up to hold the plan assets. And if you are an insured plan, you need to be sure that you are remitting the premium contributions directly to the provider in a timely fashion. The prudent selection of service providers. So we just discussed hiring service providers to assist you in the administration of the plan, but you do have a duty to make a prudent selection of those service providers. Make an informed decision and don't hire anyone knowing that that individual or that entity is not competent to do the task. Along with the selection of service providers comes the consistent monitoring of service providers. So once you delegate those duties to a third party, you cannot simply turn your back on them and expect that they will take care of everything. You have a duty to ensure that they are fulfilling their responsibilities effectively, because ultimately, as the plan fiduciary, you are responsible. The reasonable implementation of claims procedures. So this is one that is commonly delegated to a third party, either a TPA or the carrier. But again, you have the duty to ensure that the claims procedures are being implemented in a reasonable manner and that there are no issues coming up with participants or beneficiaries in relation to claims procedure. And then finally, through timely and current disclosures and communication materials. This one can be a little bit tricky to stay on top of just because there are so many required notices and disclosures, and they're often changing. The language and the information contained in these materials changes over time. So be sure that you have a system in place to keep track of all of these requirements, or have someone around to help you keep track of these. And before we wrap up our discussion on ERISA, I do want to point out that ERISA interacts with other federal laws that apply to group health plans, and these are incorporated into ERISA, and so consequently the DOL is also examining these when they are conducting an audit of your health plan. So some of the most significant provisions are the Consolidated Omnibus Budget Reconciliation Act, COBRA. COBRA applies to employers with 20 or more employees. So unlike ERISA, there is a little bit of a size limitation. And I also want to point out that we are talking about federal law. We are not talking about CalCOBRA. CalCOBRA is state law, and the DOL will not be looking into anything that has to do with CalCOBRA. The Health Insurance Portability and Accountability Act. HIPAA portability and HIPAA privacy laws both apply to group health plans. We have the Patient Protection and Affordable Care Act, the ACA. We are all very well aware that the ACA is rolling out in a major way in the coming years, and it's really the driving force behind the increase in DOL audits that we're going to be experiencing. And then the Genetic Information Non-Discrimination Act, GINA, also applies to group health plans. As far as state law goes, ERISA preempts or overrides state law insofar as it regulates group health plans. So when it comes to the regulation of your employee benefit plan, it's really ERISA and the related federal provisions that are primary. But state insurance law does continue to apply. So if your plan is insured, you do have to be aware of the need to comply with state insurance law. And state insurance law will never conflict with ERISA, but it may impose additional or heightened standards that you must comply with. So do be aware of state insurance law.
All right. Now we're going to start talking about the process of a DOL audit. So if you were to be chosen to get a benefits audit, it's going to be conducted by the Employee Benefits Security Administration. This is the agency of the Department of Labor that is tasked with regulating and enforcing ERISA. An audit would be conducted by someone local to you. So the regional offices for EBSA in our state are in San Francisco and Los Angeles, and you'll be assigned an investigator who's going to be the sole point of contact through the audit. One thing to note about the investigator is that they are not necessarily acting as an attorney in any case. They're just purely an investigator for the Department of Labor. So how we've seen the process work so far is that an employer will get a letter in the mail. It may be addressed to the company. It could be addressed to the person's name who's on the 5500 if you've been filing the 5500s. Occasionally it could come through one of your TPAs, but for the most part it's a letter that comes to your office. It's going to have a long request list for documents. It's going to identify the investigator, and it's going to request that you get on a conference call sometime within the next couple weeks to talk about your audit. This is not the time to panic, and you don't necessarily even need to get an attorney involved at this point. Our recommendation is that you make that phone call, that conference call, a priority, and probably put your entire benefits team on the call so everybody involved with benefits can hear what it is that the investigator is looking for and how the process is going to work. Now, we get a lot of questions about, well, why do you get one? We're going to talk in a few slides about how you can reduce your chances. But in some cases now, it seems to be random. So it could be chosen based on a change in your 5500 from the year before. It could be totally random. It could be due to a complaint by an employee. Sometimes you will find out the reason as the investigation gets started. Sometimes you won't. And so you'll just, as you go through the process, just try to be responsive and cooperative. So that big letter, that list of documents that you're going to be asked for, what does that look like? No two request lists are identical. They will probably vary based on the nature and the scope of the audit. But what we've seen so far from our clients that have had that is that there is the standard list that everybody gets, whether you're fully or self-insured. The list that I saw prior to January 1 of this year was about 5 pages long. The list I've seen twice now since January 1, adding all the ACA requirements, is 7 pages long. Don't panic. You don't have to get it together in time for the conference call. You'll get your list, you'll get on the call, and you're going to find out what it is that they're looking for. He's going to ask for a huge list of documents. What you will eventually have to show may be different if you're fully insured or self-insured. And this document list is going to serve just as a starting point. What we've seen so far is that the investigator is going to go through it in chunks. So they're going to start usually at the beginning of the list. They're going to ask you for a chunk of documents. You're going to agree. He or she is going to give you a week or 10 days. Is that reasonable? You'll agree that that's reasonable, and then you're going to get those documents to them. All right. So what does a typical DOL audit, what are the documents that they're looking for? So like I said, there's going to be 7 pages of them. The list will be the same for fully or self-insured employers, though what you will ultimately probably be providing may be different. So the first thing is they're going to be looking for all of the plan documents. So plan documents would include your summary plan description. Now, if you have a summary plan description that's 80 pages long and includes everything, you'd probably submit that whole thing. If you have a wrap document, however, where it's featured, say, on a benefit website with all of the other various pieces that go along with the wrap document, you would either have to get all of those documents together, or what we've done is provide the investigator with the link to that benefit website, and it just needs to have everything that you refer to in the summary plan description. This would include any summaries of material modification. That's when you change your SPD and you don't redo the whole thing, you just add an addendum. Any of your annual 5500 reports for the 3 most recent years, any qualified medical child support orders, and what your procedure is for that. You would also be asked for contracts with your insurance carriers, any evidence of coverage booklets, and your contracts with any other service providers and the related invoices. So you're not going to be asked necessarily for a copy of every invoices that you've paid to your COBRA provider, but they may ask you for your contract, maybe a sample invoice, and they're going to ask you quite a bit about how the process is, how you communicate with each other and work together. You may also be asked for trust documents, claims processing arrangements, any reinsurance. So if you are fully insured, at this point what you're going to do is probably have them contact your insurance carrier. A lot of this will be handled from that end. But if you are self-insured, a lot of this information may be coming from you. You may also be asked for enrollment forms, evidence of premium payments, any payroll deductions. What they're looking for in kind of summary is they want to make sure that an employee or a plan participant can access all the information that they could possibly need about their health plan, and they want to ensure that the money is being handled correctly. So as Deborah had mentioned, the reason that a lot of these the number of audits is being increased has to do with the Affordable Care Act. So there's also some documents that are new in the last couple of years that they're going to be asking for. The first is, of course, a summary of benefits and coverage. Those are those 6-page blue documents about each plan that you provide. They're going to want to make sure that you're providing those to your employees. Also, your health insurance exchange notice is a very important document. They're going to be looking to make sure that you've communicated properly with your employees about the exchange, that your eligibility language is consistent, that sort of thing. They want to ensure that children up to the age of 26 can enroll in your plan, and any documents evidencing any lifetime or annual limits imposed on or after the implementation date of September of 2010. Also, any instances of rescission of coverage, your notice of patient protection, and documents relating to the provisions under preventative care services. So again, if you're fully insured and you're providing your EOCs and your SBCs in a timely manner, all of that information would be in there. If you're self-insured, it would be your own SPD probably. If you have a grandfathered plan, they're going to want documentation that you have disclosed that to your employees, and any records you've used to determine that you are a grandfathered plan. And they're going to want to look for documentation around the proper distribution of the medical loss ratio rebates. So those are those rebates that if you overpay the carrier and the carrier has to reimburse you, they want to make sure that you are getting the share to the employees as is appropriate. In the last audit we did, they seemed very concerned. It was an employer who actually paid 100% of the employee independent contributions, so you wouldn't think this would be an issue. They were very concerned about how you could show that you documented that you provided all the right communication and any MLR rebates to COBRA participants. And so as you're thinking about all of this, always remember those COBRA participants that may be out there that are still on your plan. Some of the other documents that they're going to be looking for related to both HIPAA and COBRA, that would be your Notice of Special Enrollment Rights, your Notice of Privacy Practices, any materials relating to any wellness or disease management programs, especially if participation affects premiums, that sort of thing. They're going to want to see evidence of non-discrimination. What they're looking for here are probably in rates, eligibility, make sure that everybody has the same access. Compliance with the Newborns Act and the Women's and Health Cancer Rights Act. Those are notices that have to be provided to your employees, generally within the SPD. And any documentation around compliance with GINA, that there's no genetic discrimination going on. This would also be probably related to your health plan, to your wellness plan. Along with that, they're going to ask for COBRA documentation, so COBRA notices, general notice, election notice. We haven't seen an auditor ask for specific. It's been always asking for general templates, what is being sent to employees that are eligible for COBRA. But again, it would depend on why you're being audited. All right. So how does it work? So submission of documents can be made electronically, and that is generally preferred. So like I said, when we've been through this a couple times with our clients, the auditor says, hey, I would like to see copies of all of these things within the next week, 10 days. Is that doable? You agree that it's doable. And then you just email those documents to the auditor. We have also then given him access to our benefit website and said, hey, these are all the documents that are available on the benefit website. It's available to both employees and COBRA participants, and that has sufficed very well. One of the things we hear sometimes when we go out to new clients is that they've heard somewhere that they should have an ERISA binder. There's really no such thing as an ERISA binder, because if you were to be audited, the list of documents is always flexible. Also, they don't generally come to your place and ask you for a binder of information. You could get an on-site audit depending on the nature of the audit, but really even at that time they're going to ask you for different samples of things you can't really predict. So there's no point in having a hard copy binder around somewhere preparing for an audit. You should expect that you won't have all of the documents being requested, and so it's fully okay for you to encourage the investigator to talk to your carriers or your TPAs. And so what we've done is we've put the investigator in, when they want to talk about claims processing and things like that the employer doesn't really have a lot of control over, we put them in touch with whoever the rep is at their various carriers, COBRA administrator, that sort of thing. The duration of the investigation totally varies. It can take weeks, months, it could be a year. Like I said, the investigator will usually go through this in chunks, lesser pieces, you get them pieces. So this can take a while, and try to not get frustrated with the process. But the big thing that we can tell you is that you should be cooperative, and you should make it clear to the investigator that you are making this a priority. And so, there may be a time that they ask you for something and you're not going to be able to get it done in the next few days. Totally fine. Tell them that you're very busy, that you can't, but let them know clearly that you're making this a priority, you're being cooperative. And our experience so far is that, they really aren't out to get you, and we haven't had an audit that gets combative.
Okay, so once you've made it through the investigative portion of the audit, you really come out on the other side to the closing phase. And the closing phase of the investigation occurs in two different phases, the first being voluntary correction. So voluntary correction will only occur and will only take place when violations have been found. Keep in mind that relatively minor violations are not uncommon. So the chances of you being faced with voluntary correction are quite high. Voluntary correction is the first line of enforcement when violations are identified by the investigator, and many of these violations, I would say the vast majority of these violations, can be self-corrected. And these violations will be clearly identified by the investigator. So the investigator will clearly communicate to you what violations have been found, and he or she will also make clear to you what steps need to be taken to remedy the violation. There will be no guesswork necessary on your part to figure out what exactly the violations are or what you need to do. And if you feel like you're guessing, then just go ahead and ask the investigator for some further clarification here. Voluntary correction requires documentation of the steps taken to effect the correction, including proof of participant distribution where necessary. So some examples of self-correction and the corresponding minor violations that may occur are the updating and distributing of the SPD. So perhaps your SPD is missing a required notice or some essential language, and the investigator points that out to you. So perhaps the voluntary correction here will be just updating the SPD to include that language and then distributing the updated SPD to all of your participants. More examples, providing access to the plan's claims procedures on a benefit website, and then updating disclosure forms with current language. The final piece to this whole process is the closing letter, and this signals the official conclusion of the investigation. The letter will follow voluntary correction if voluntary correction took place, but do keep in mind that it's possible to take up to several months to actually receive the closing letter. So be prepared for a little bit of radio silence between the time that you finish voluntary correction and receive the closing letter. So the closing letter will be provided by the investigator, but will actually be signed by the regional director, which is probably the first time that you've seen the regional director's involvement. The letter will outline any findings made during the course of the audit and will summarize any corrective actions taken. This closing letter is very comprehensive. It details from start to finish the audit that took place, and it clearly lays out any and all violations that were identified and then the corresponding corrective actions taken to remedy those violations. The letter will also have an indication of no further action with respect to the issues raised in the audit. And this is why sometimes the closing letter is known as the no action letter. And this is important because it signals that the Department of Labor will take no action with respect to the issues raised in the audit. So anything that is in that letter, it is done, essentially. The Department of Labor will no longer pursue any of those issues. However, the closing letter has no effect on other agencies or private parties. So it does not preclude another agency like the IRS from stepping in and conducting its own audit. And it certainly does not preclude private parties like participants or beneficiaries from pursuing action.
All right, so how can you minimize your exposure to begin with? All right, the first step would be to look at your annual 5,500 reports. So 5,500 reports are due of employers who have 100 eligible participants at the beginning of the plan year. So if you're a mid-sized employer that maybe only has 84 people on your health plan, but you have 100 people on your life insurance, then you are still considered a health plan with 100 participants. So you're required to file an F5500 within 7 months of the end of the plan year. They're all done online now, and so it's a lot easier, I think, for the DOL to compare and look for errors because they're all electronic. So incomplete, inaccurate, or missing reports are a common trigger for an audit. So if your 5,500 isn't something that you've paid much attention to or have been involved with, or if you're new at your employer, it may be one of the things that you want to look at and make sure they're consistent. And so you'd want either the same person or the same firm doing them each year. If you switch brokers and they have different CPAs who do them, you're going to want to make sure that whoever's doing it this year sees the report from last year, and you're going to want to make sure that the name is consistent and the information provided is consistent. One of the things we've also seen is employers that use a different name for their health plan than what's being used on the 5,500. You're going to want to make sure you're consistent across the board. And you want to ensure that your 5,500s are done timely and filed by somebody who is qualified to do so. There are extensions, but you know they're kind of a technical document, but really shouldn't take that long to complete, and so we recommend that you get them done in a timely basis. The DOL also has a voluntary correction program. So if you know that you're a larger employer that should have been doing them and you have not in the past, you are much better off to voluntarily go in and correct it than to have the Department of Labor find out that you have not been doing so. All right. The next thing talks about disclosures and responsiveness. Employee and participant audit or complaints are a major reason for the investigations that are done annually. These complaints often stem from the lack of communication materials as well as the denial of claims. Now, if you are a fully insured employer, you may not have much control about the denial of claims, but you have a lot of control about the communication materials. And so what you want to do is make sure that your communication materials are being provided timely, that your employees can understand them, sometimes in the language that they speak as a first language, and you're going to want to make sure it's done timely and that it meets all of the requirements, that employees can find the information that they need easily. You want to be diligent about reviewing and updating your communication materials. There are some time deadlines for some notices. For others, you have to just show that you're trying to do your best to meet your fiduciary responsibilities. You should respond promptly to all requests and inquiries from participants. If something isn't being paid or they need additional information, you should be timely and respond to them very quickly. Because remember, even unsubstantiated complaints can expose vulnerabilities. So we've seen employees make a complaint because a claim wasn't paid, and that was actually done properly, but the lack of a timely SPD being available to the employee could end up ultimately being the problem that the employer faces. Some other agencies, too. Other agencies and audits can uncover issues that will then be referred to the Department of Labor. So if you get an audit that doesn't go well from another agency, so that should be kind of a heads up that it could trigger a DOL benefit plan audit. The IRS and the DOL do share overlapping regulation and oversight. The Department of Labor does have a coordination agreement with the IRS. And overall, company compliance will lessen the potential for referrals to the DOL by other state and federal agencies.
Our next set of tips for you concern some common pitfalls to avoid. So these are common mistakes that are made or issues that are overlooked throughout an audit, and we want to give you a heads up on those so that you can be sure to avoid those and not fall into the same trap. So the first common pitfall to avoid, never backdate documents. So issues of noncompliance cannot be remedied retroactively. And it may be tempting when you start collecting the documents that are requested. You might notice that you're missing some documents. It may be tempting to go ahead and draw up those documents and then backdate them, but I cannot stress enough, do not attempt to feign past compliance by drafting and backdating documents, especially things like your SPD or your disclosure notices. Backdating constitutes fraud, and it carries serious consequences, potentially criminal. The Department of Labor does have the authority to pursue criminal action, so you definitely do not want to find yourself in a position where you attempted to correct a relatively minor error and then ended up in a more serious situation. As we discussed previously, many issues concerning past noncompliance can be addressed through voluntary correction. So just let the process play out and let the investigator basically guide you as to what you need to do. You also want to be sure that you designate a single person within the organization to serve as the representative and contact person throughout the investigation. So this person, of course, will need to be familiar with and knowledgeable about your benefit plan, and they will also need to be competent to respond to the investigator and keep the process organized. So it's probably going to be someone in your HR or benefits department. But this person is really going to serve as the gatekeeper of information. This will allow for a smoother, more controlled process. So you definitely want to have control over the flow of information here. And having a single point of contact will also avoid the duplication and contradictory communications that could occur otherwise. This will also help the investigator because then he or she will know exactly who to contact, and they can establish a good rapport with that individual. So you're really helping out the investigator here and in turn helping out yourself by making the investigator's job easier insofar as knowing exactly who to contact and then having a cooperative relationship with the investigator. Another common pitfall to watch out for is be sure that you narrow the scope of document and information requests. You're going to be getting a lot of requests for documents and a lot of questions being asked. Be sure that you ask the investigator questions to clarify exactly what is being requested. This is an ongoing conversation with the investigator. It's a two-way communication line. So if you're confused about what's being asked or if you're not sure exactly how much to provide or what the investigator is looking for, do not hesitate to ask for clarification. You definitely want to avoid providing more information than what is required because this could really result in unintentionally exposing your organization to potential violations that may otherwise have gone undiscovered. Also, you do not want to hesitate to ask for more time. Michelle mentioned earlier that deadlines are often flexible, and that is completely the case. So a lot of the requests that you'll receive do come with a deadline or with some expectation of a deadline. But investigators are often amenable to reasonable requests for an extension of time. So that deadline is often not a hard deadline. And if you need a few more days or maybe a week to get things together, don't hesitate to ask. Of course, if you're going to ask for, a month of additional time, that might not be so welcome by the investigator, but Nevertheless, don't hesitate to ask for a little bit more time. Extensions of time will allow for a more thorough process of gathering information and involving the appropriate individuals. So in order to demonstrate total cooperation, be sure that you communicate your need for more time and you don't just assume that it's available. And the last pitfall to avoid is do not provide documents or information without prior review. This may seem like a little bit of a no-brainer, but as the process goes on and sometimes drags on, it's really easy to just start throwing the information at the investigator without properly reviewing it first. So you want to ensure that there's a careful review of all documents and information provided to the investigator prior to handing that over. You want to be sure that the information provided satisfies the request and that it is also limited to the issue in question. Along with this, you want to keep track of the information that is provided throughout the audit. So this is really easy to do if you're providing information electronically. If you are providing documents electronically, it's so easy to just make a copy of any file that you provide. And when you're answering questions, when possible, do so via email. That way you have record of exactly what the investigator asked of you and then exactly what information was provided. If you're talking over the phone during conference call, be sure that the notes you take are accurate and detailed so you can refer back and find out exactly what was asked and exactly what was answered. So our last set of survival tips for you this morning involve when you can seek assistance. And the first person you may think to involve when you become aware of an audit taking place is your attorney. And your attorney can be extremely helpful. They can assist from the very start by reviewing documents, formulating answers to questions, and probably most helpful, serving as the organization's designated representative. But it's important to note and keep in mind that legal representation is not required during the investigation. And oftentimes, actually, investigations and audits are completed successfully without the assistance of your attorney. So while you are certainly able to involve them at any stage of the investigation, don't feel pressured to do so if you don't need to. Your attorney, though, should really become involved upon the signal of any particular red flag that may occur throughout the investigation. And these red flags might be something like the discovery of extensive gaps in your compliance strategy. If you become aware of extreme gaps or major issues of noncompliance, maybe even willful misconduct at any point in time, definitely get your attorney involved and then they can help you in responding to the investigator. Violations that cannot be remedied through voluntary correction. So if the investigator comes back to you at the end of the audit and lets you know that he or she has found some violations and voluntary correction is actually not available as an option to remedy those violations, he or she might be talking about a settlement agreement or restoring losses to the plan. Be sure to get your attorney involved there. And then finally, if the investigator pursues interviews with key individuals by means of administrative subpoena. So the Department of Labor does have the authority to issue administrative subpoenas to compel testimony. And while it's really rare in the group health plan context, it can happen. So if you or anyone within your organization receives an administrative subpoena, definitely get your attorney involved. Another person who can really help you out quite a bit throughout an audit is your broker. So you should really let your broker know from the start that you've been selected for an audit, because your broker can assist in collecting documents, providing answers to questions, and identifying the information that can be supplied by other parties like your insurance carrier. Your broker can also be involved in conversations with the investigator as much or as little as you want them to be. But unlike your attorney, your broker cannot be designated to speak on behalf of the organization. So your broker can be involved in conference calls, in emails. They can be copied in on those emails, and they can really help you immensely with gathering documents and answers to questions. But the investigator will never speak directly to your broker when trying to gain information about your organization. And then most importantly, your broker should really be an integral part of your proactive compliance strategy. Don't wait until you receive notice of an audit to get your broker involved with compliance. So your broker should be involved with helping you keep track of what's required of you and keeping your plan compliant so that when and if you are faced with an audit, it will just go that much more smoothly.
All right, so here we have some links that you could use for resources. There's some DOL checklists. These are the actual checklists that the auditors start the process from. We also have some compliance publications on Felice.com, and this morning we loaded on Felice.com as a top document. There is a document that goes along with what we have done today with a checklist. You can also download the slides from this presentation from this site. So on that front, we're going to take, here is our contact information also. So Michelle Montoya, that's myself, Deborah Hyde, our ERISA attorney. You can email or call either one of us for documents or more information about any of the slides. And on that note, we're going to see what we've got out there for questions. We have a question, does a COBRA administrator assist with MLR rebates? Will they prompt the broker and or employee? So the COBRA administrator, so far in our experience, they would not be aware of an MLR rebate unless you were to tell them. They would probably help you with the calculations, but no, I don't believe they wouldn't reimburse any of the money. They may just help you figure out who was on the plan when, how much did they pay, so that you can see if any of those dollars were to go to them. But no, it's pretty much the employer's responsibility. All right, we've got a few more minutes. Any other questions? All right, on that front, I hope that this morning has been helpful. The information, as we've showed you some links, there's also some documents on Felice.com that we can help you out. And feel free to contact anybody on the compliance team for more information. Thanks a lot, and have a great day. Bye-bye.